So understanding what intellectual property means and what are those different parts and how it could be useful to anyone that's out there that has an idea, or they're writing a novel, or they're creating some music, or they're working on a machine that's going to bring forth a better way of servicing a certain sector of the world. So intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs, and symbols. Is protected by law through trademark, copyright, and patents. And like I said, the Constitution, it supports everything, every part of life, everything you can think of, every part of law. It's supported by the articles and amendments that are put together and are built into the Constitution. So continuing right along here with my notes from my notepad here. So Article 1, Section 8, Clause 8 of the Constitution. It's known as the Intellectual Property Clause. And this clause gives Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their prospective writings and discoveries. So the intellectual property clause here was a clause that brought forth by Congress, and it gives a limited amount of time for authors and inventors to have those exclusive rights. They have total control over how that particular invention is marketed, how it's monopolized. Exclusive rights are uh, very important to have, and the exclusive rights are a powerful legal tool that grants to a person or entity to use, license, or monopolize their product and preventing unauthorized use. That's what exclusive rights does for inventors that come up with a trademark, that come up with a patent, that come up with a copyright as well. Gives them that exclusive rights, that protection. And as we go further along into this, so let's look at a trademark. What is a trademark? Trademark is a legally protected symbol, design, or phrase that distinguishes these goods or services from those manufactured or sold by others. So that's what a trademark is. A trademark is a legally protected symbol, design, or phrase that distinguishes a company's goods or services from those manufactured or sold. And we could take a look here. Just kind of want to give you a better example of exactly what, for those individuals who don't know what a trademark is, this should give you a better understanding of what it is here. Let's take a look here. Everybody's familiar with the Nike sign. Everybody's familiar with the Nike, the wording, the Just Do It. Everybody's familiar with that, and that's a brand. That's a trademark and or a brand. And this information here, it's located on the United States Patent and Trademark Office, the USPTO. They That is the particular organization that you would go through to get everything registered, to get your trademark registered, to get your patent registered as well. And that's just one, just go through this example again. So a brand is a marketing concept tied to how people feel about a product or service. Companies use different colors, images, and qualities to influence these emotions. For example, a certain brand might make you feel confident, calm, or secure. Another might make you feel eager or excited. A trademark, on the other hand, provides legal protection for a brand. It creates enforceable rights in a brand's identity. Traditional types of trademarks include brand names, slogans, and just as I continue to look here, these are different types of trademark. Payless. Everybody's familiar with U-Haul, PNC, different types of trademark names. And like I said, there's a lot of great information on the USPTO website that will give you a great understanding of trademarks, patents, copyrights, information that's right here at our fingertips, and it's free. So I want to go back into my notes here. I'll go back to my notepad to get some additional information here. So also, U.S. federal registration initially lasts 10 years and can be renewed indefinitely in consecutive 10-year periods if the trademark owner continues to use the mark in commerce and pays the required renewal fees. So, as I stated earlier, remember that Congress set up the trademark law to allow individuals at limited time to have those exclusive rights to whatever brand, trademark, copyright, or patent that they would come up with. And they're under that protection, like as far as saying with the trademark, it's 10 years, and then it can be renewed for another 10 years. And all you have to do is to make sure that those renewal fees are paid. And then we take a look at copyright. Copyright are rights provided to protect the original works of authorship fixed in a tangible medium or expression. And we think of copyright, let's focus on the works of authorship, author, writer, books, music. And just as I have stated here, includes such things as literary works, musical works, dramatic works, pictorial works, graphic and structural works, motion pictures, and recordings. All those different areas are covered under the copyright law. Copyright duration varies for works created by single individuals after January 1st, 1978. Copyright lasts for the life of the author plus 70 years. So you got 70 years of protection, you got plus 7 years. You got the full life of the individual that brought forth the material and plus 70 years. For works created by multiple authors, it's 70 years after the death of the last surviving author. And the only different thing about the copyrights, everything else as far as patents and trademarks are handled through the USPTO, United States Patent and Trademark Office. But for copyrights, they're handled through the US Copywriting Office. And let's take a look at patents. A patent is a form of intellectual property protection that grants an inventor the exclusive rights to exclude others from making, using, selling, offering for sale, or importing the invention for a limited period of time. The rights are granted by a government entity such as United States Patent and Trademark Office, as I covered a little earlier here. So that's what a patent is. Now, once a patent expires, the invention enters the public domain, meaning anyone is free to make, use, sell the invention without permission from the original patent holder. So it just goes back into the public domain, where there's public access, where anybody else can use it, can enhance it, or so forth and the other. But also reiterating again about the United States Patent and Trademark Office. Uh, It's a federal agency that examines and grants patents along with registering trademarks. This agency is also responsible for protecting intellectual property in the United States, helping to drive innovation and competitiveness. So if there is a patent, if there is a trademark, if there's an idea out there that you have, the USPTO will be assisting you, being to assist you with getting that patent or that trademark registered and getting protection on your the creativeness. Now, there's different types of patents as well. There's a utility patent. These are the most common type, protecting the functional aspects of an invention, such as how it works and what it does. They cover processes, machines, articles, and manufactured compositions of matter and improvements thereof. Utility patent applications filed before June 8th, 1995 last for 17 years from the issue date or 20 years from the earliest filing date. On or after June 8th, 1995, the patent term is 20 years from the earliest filing date. So it just goes back to stating again, Congress setting up the uh, int intellectual property clause that allowed those exclusive rights for a limited time. And like I said, it's great that that was plugged in, and this is allowing individuals to have those exclusive rights and protections to their inventions. Now, the another type of the patent is a design patent. These protect the ornamental designs of an article of manufacture, essentially how an item looks. Design patents last for 15 years from the date of grant if filed on after May 13th, 2015. 15, 14 years if filed before the date. And then you also have a third type of patent, which is a plant patent. These are granted for a new and distinct varieties of plants that are sexually reproduced. This includes cultivated sports, mutants, and hybrids. Plant patents last for 20 years from the date of the application filing. So as we look at those three different types of patents there, and we look at, also going over the different amount of years and times that they are protected for, that's, the information I wanted to give here as an introduction to intellectual property law. Now, as I continue to do more shows, like I stated, I have a great interest in the Constitution, constitutional law. I have a great interest in intellectual property law. Now, and there's other different areas of law that I will be talking about and examining on this podcast for the show. But those are the two main areas that I have a great passion for at the moment. But we will be taking a look at many different cases in many different fields of law. And like I said, I'm coming to you as a legal novice. I'm coming to you as an individual who's learning the law, who's looking on different websites and who's also, if you have access to Westlaw and other things to fact check and just make sure what I'm looking at is exactly what's correct. And I just want to share some websites with you as well that are out there that could be helpful. And also want to add this in as well. This is a great website here. It's called the Constitution Annotated. There's a lot of great information. It breaks down the Constitution, breaks down the amendments and everything that's within. And I wanted to go back just to kind of give some history as under the Articles of Confederation. Now, I'm thankful for the Constitution, thankful for the Articles of Confederation, but there were some things, the intellectual property law, for protection for individuals with creative minds that under the Articles of Confederation made it very challenging for those individuals to make sure that their inventions were protected. And this is why, as is stated here, under the Articles of Confederation, the federal government lacked power to grant copyrights or patent. They lacked that power. Recognizing the limits on its authority, the Continental Congress passed a resolution in May 1783 calling upon the state legislatures to enact copyright legislation. All of the then existing states except Delaware adopted such laws with verifying scope and terms of protection. Similarly, to the extent patent rights existed at all during this period, such rights derived from varying states. So as I stated on one of my previous shows, and just the things that just were lacking, and the Constitution has definitely improved and made the country living better, and has a great protection for individuals and great protection for areas like intellectual property law. And just to continue on with this patchwork of state by state protection created difficulties for authors and inventors. Obtaining multiple state copyrights or patents was time consuming, expensive, and frequently frustrating. In April 1787, James Madison deplored the want of uniformity in the laws concerning literary property. Though he conceded that the issue was of inferior moment compared to other concerns facing the early republic. Perhaps for this reason, neither the early plans of government presented at the Constitutional Convention nor the first draft to the Constitution mentioned intellectual property as being that important. But later on, they did make the adjustments needed to make sure that individuals wouldn't have to feel like they were going through so much of a hassle to get their inventions protected. And that's, like I said, that's just a little bit of history on how things changed from the Article of Confederation to the Constitution that we have governing us today. And this is another good site, the Bill of Rights Institute uh, breaks down the Constitution and some other things. This is another pretty good website to take a look at. This is something earlier that I showed that I was able to get from the USPTO office, and it's a registration toolkit. which will take you through the steps that are needed into filling out the application, moving through the process, preparing the file, understanding the process. Like I said, they're a great source, making sure that if you have an idea or an invention or something out there that you want to get protected, USPTO. And like I said, if you have access to Westlaw or LexisNexis, you can also fact check different things there. And right here, I'm just taking a look at intellectual property, um, you know, through practical law. And you have the different areas that are listed here: copyright, entertainment, general IP, information technology, trademarks, all that stuff there. But that's only if you have access to Westlaw or LexisNexis as a kind of just a backup to fact check. And another great website is Justia, in which I get emails throughout the week on different court cases, different things that are happening in different areas of law, not only intellectual property, but the criminal, many different parts of law can be accessed through Justia. And they have a great load of cases and information that you can look up on this site as well. And let's see, of course, there's always Google. You can find anything on Google. So I do appreciate each and every one that will get an opportunity to listen to this. I do appreciate you tuning in, and I'm hoping that as I get better here, as I get, as I sharpen up my pencil, you also will, join in as a legal novice, and let's learn law together. Until next show, take care.